Hello, doggies. I hope you're all doing great. This video is being presented by Credence Law Learning for education purpose, and we are going to discuss practical-oriented questions. And for 100 pattern, it's going to be a compulsory question, that is question number 9, where you will have to write 2 questions out of 3. So it's like 2 questions, each carrying 10 mark, for the practical-oriented question. First question, A and B enters into an agreement where A says that he is going to pay 10,000 to B if it rains on a specified date. And accordingly, it rains on the specified day. Now the question is, can B recover the amount from A in the court of law? Here, wagering contract attracts, the provision of the wagering contract attracts to this question. So wherein it says that if there is any contract which is wagering in nature, something which is dependent upon the happening of uncertain event is illegal and void under the section 30 of the Indian Contract Act. By virtue of section 30, so the given question is, in the given question, the contract is void. So A cannot, the contract is void, and now B cannot recover the amount from A in the court of law. And if for this kind of questions, first you're going to write the facts of the case and what is the issue raised, and a conceptual clarity to the concept given. If wagering war, you're going to write half a page to the concept, and then you're going to mention its judgment and reasoning, and finally you're going to conclude. And then coming to the next question, A kidnaps B's son and threatens to kill B's son if he don't sign it on the contract. The signature was taken by threat. Now the question is this valid? What can he do? Facts of the case goes this way. A kidnaps B's son, where he threatens B to sign it on the paper so that he, so that he give back the son, B's son. Now the question is, out of fear, B signs it. Now here, the consent was taken by virtue of section 15, that is coercion, by coercion. We have section 13, which talks about the meaning to the term consent. Consent is where two people agree upon the same thing in the same manner, in the same sense. And consent is said to be free if it is free from undue influence, coercion, fraud, mistake, misrepresentation. Hence, here in the given case, section 15 is getting attracted. So here, consent is said to have not been taken by free will. It is taken by threatening a person under which is prohibited by IPC. Here, B's consent is not free as it is obtained by threatening him. So here, as per section 72, it says that if there is any contract which is done by virtue of coercion, mistake, then it can be set aside. The party can set aside. Yes, he can set aside the contract by virtue of section 72. And then we have the third case here. A dancer agrees to dance in the theater of B at a future date. Before the occurrence of the event, she met with an accident and she dies. I mean, she met with an accident and she lost both the legs. Now the question is there is a breach of contract? The answer to the question is no, it is not a breach of contract. Here, the event became subsequent impossible. That is supervening impossibility. The agreement became void on the ground of subsequent impossibility, supervening impossibility. By this we can say that here the contract is void, where B cannot sue against A for the breach of the same. Lex non cogit A ad impossibilia. Law does not compel impossible things. Here the doctrine of frustration, that doctrine of impossibility is getting attracted, by virtue of which B cannot sue against A for a breach of contract. And then we have, and it's just a quick information about the class notes and the guidance available. If you are in need of the classes, notes and the guidance, you can contact to the number given. And the next question that I've taken up here is, M's son was missing. He sent a servant in search of a boy, and subsequently the person who just asked the servant to get the son back announced the offer, saying that whosoever gets the child is going to give them the offer. He is going to give them the offer of 1 lakh rupees. Now the question is, can a servant claim the reward? Answer to the question is no. Why? Because one of the feature of the offer is offer must be communicated beforehand. Since the offer was not communicated beforehand, here the servant was not entitled to get the compensation, get the reward. This case is attracted, and then this question attracts the case which we have already dealt in the essentials to the offer. Here, the case which attracts is Lalman Shukla versus Gauri. Then Lalman Shukla versus Gauri, that where a servant came to know about the contract after she discovered a boy, and then the court said the servant already had an obligation to um, uh, oblige to the calling of the master. Hence, the servant was not entitled for the reward. Your one essential of the offer is not getting attracted. That is, offer must be communicated beforehand. For this kind of questions, what you're going to do, you're first going to give the facts of the case, followed by issues raised, and then you're going to talk about essentials to the offer. Give the definition to the term offer and write about the essentials and explain offer must be communicated this particular point a bit detail, like 2-3 lines details, and mention about Lalman Chukla versus Gauri, that case. Here, hence the servant is not entitled for the reward. And the next case is, just a minute, I'm not able to screen. Okay, so the next case is Ajay sold his electric car worth 7 lakh for 70,000 to the Vijay. Can the sale be set aside? Here, the concept of consideration is getting attracted. What consideration says is, for a contract, consideration is one essential requirement, one essential element to the contract. Here, but it is not necessary that the consideration should be of the adequate value. Here, the consideration need not be adequate. There must be something in written. By virtue of this principle, we can say that the transaction which happened between Ajay and Vijay is valid. For this question, give the details to the concept of consideration and elements to the consideration. And then the next question is, husband promised to pay 3,000 as a household allowance every month to wife. Later, husband defaults the promise. Now, the question is, can wife sue for the allowance? Here, one element of a contract is, contract to be questioned before the court of law must be legal in nature. It must give rise to the legal relationship between the parties. Here, the case of Balfour versus Balfour is getting attracted, wherein the case of Balfour versus Balfour, husband promised to pay his wife a household allowance of 30 pounds every month. Later, parties separated and husband failed to pay the amount. Now, the question was whether the wife will be entitled to get the allowance. No. Why? Because it was a social relationship. It was a social contract which cannot be questioned before the court of law. And then we have the case B has a marriage hall from C. The hall was accidentally burnt down before the marriage took place. Can B file a suit against C? Here, the concept of doctrine of frustration is attracted, where it talks about subsequent impossibility, destruction of subject matter. The given case is similar to that of Taylor versus Cadwell, where she agreed to let out a music hall to tea on certain date. Before these date before this date approached, the hall was accidentally burned. The court said here it was the doctrine of impossibility. There was a frustration where the subject matter itself destroyed, so the party cannot question it. So the contract in itself is void. And then we have again, due to husband's threat of committing suicide, wife executed an agreement to transfer the same to husband's brother and his father. Actually, this case is similar to that of Chikkam Ammi Raju versus Chikkam Seshamma. Here, section 15, it is about the coercion. Coercion is getting attracted in a coercion wherein it says that if there is any act where it is done by coercion, by compelling the party, by threatening the party to do something. If you don't do that, this would be the consequence. If we're threatening the party to enter into an agreement, that becomes coercion under section 15. So that the contract become voidable in nature. Yes, she can revoke the agreement. She have a right to revoke the agreement. And then comes a dealer in fruit leaves a box containing fruits in B's house by mistake, and B consumes the same. And can A recover the value of the fruit from D? Decide. B, decide. Here, no. Why? Because it's a quasi-contract. Quasi-contract in the sense, though there was no contract between the parties, the transaction which happened between the parties is kind of a contract. It says that no one shall enrich himself unjustly at the expense of other. So by virtue of this concept of quasi-contract. So quasi-contract is a legal obligation that the court imposes where there is no formal contract between the parties. It's kind of an implied contract. It's kind of an implied contract. But by virtue of quasi-contract concepts and by virtue of section 70, the yes, A was entitled to recover the value of the fruit from B. And then the question we do have here is, a minor bought a watch on credit for 500 but later failed to pay the same. And seller sued A for the recovery of the price. Can he recover the price? Here, no. Why? Because a contract with a minor in itself is void. A contract with a minor cannot be enforced because minor is someone who is incapable of understanding the consequences of an act. Minor, someone who is below 18 years, cannot enter into a contract. It's a legal provision. Since section 10 and 11 is not getting fulfilled, the seller was not entitled to recover the price because seller before entering into a contract must have been taken caution. Here, this given case is similar to that of Mohiri Bibi versus Dharmodas Ghosh, where the Dharmodas Ghosh, a minor, mortgaged his house for 20,000 to money lender, but the mortgagee money lender has paid 8,000 rupees, and subsequently minor said that he is not going to enter into a contract. They just want to cancel the contract. Then what happened? The mortgagee asked for the money, like asked for the 8,000 rupees to be given back. Later, minor said he's not going to give. And court also agreed to this point, saying that any contract which is entered into a minor in itself is void. So this is the case, a minor's contract cannot be entered, which is void in nature. So these are the few important repeatedly asked questions. If you have any queries and if you have any questions, you can contact to the number given. All the best for your upcoming exams, and hope to see you all in the next video.